my name's Andrew, and welcome to this webinar, which we are doing on notifying the board. I'm just going to start by sharing my presentation. You'll note there's a Q&A box down at the bottom of the screen. So if you've got any questions, please put them into the Q&A box and I'll attempt to answer them. And there'll be an opportunity at the end too for people to ask any questions as I work through this presentation. Should take around 20 to 30 minutes. Yeah, so I'll start by finding my presentation, share that with you, and then we'll kick off on this subject. So hopefully everybody can see the presentation. It's about notifying the board around the areas of health, competence and conduct. And also in part of health and competence is also fitness to practice and to register initially as an occupational therapist. So I just want to get this set up properly. Hopefully you can see this okay. The first bit is around the so the legal framework is the first part of the legislation, and obviously it is the Health Practitioners Competence Assurance Act of 2003, which has 7 parts in total, and the one that this presentation is going to be talking about is part 3 and part 4. Part 3 is about competence, health and fitness to practice, and part 4 is about complaints and discipline. And these parts describe the legal actions the board can take when dealing with notifications. So that's the premise on which we operate, is the Health Practitioners Competence Assurance Act, HPCAA. Obviously that's the legislation, and the board has policies and processes to manage notification, which flow from directions within the Act. And our website contains information about the complaints process, and guidelines for competence referral are also on our website. There's some documents you might find useful if you're ever faced, of course, with having to consider notifying the board about a practitioner. Health notifications, these are basically around the inability of a person to perform the required functions of an occupational therapist due to mental or physical condition. I'm just going to change my screens around so I can see what I'm doing. Sorry, it's been moving back and forth here. Yep. Perform the required functions for due to mental or physical condition. So those people who can notify, you only have to have reason to believe that the person has a mental or physical condition which could affect their practice. The people who can notify the board are a person in charge of an organization that provides health services, a health practitioner. So if you're a health practitioner of any type, you can inform the regulator, the OT board in our case, that somebody you think or consider has a mental or physical condition which might affect their practice. A member of the public can notify us. An employer of a health practitioner can notify us, a medical officer of health. And when students or graduates come to register for the first time, we get a letter from the head of school about all new graduates, and in that letter the heads of school might identify one of the graduates as a a health condition, either physical or mental, that may affect their registration. And that's something that we would gain further information about, make further inquiries of. And the Act says that the person notifying must promptly give registrar written notice of all circumstances. That doesn't preclude you from calling us and talking to us about a particular issue or concern that you might have, but we like to have information in writing and communicate directly with people. That's probably the best way to operate for us, so that we're very clear about what the information is that we have, and yeah, what's required. So moving on. So what action can the board take when it gets a notification and has considered it and done a full assessment of that notification that comes in around health issues? We can, of course, take no further action, and we often do that in relation to, for example, a new graduate who might be a diabetic. Obviously that's not going to affect practice. That person's had that condition for a long period of time. Somebody may have had a concussion injury during their undergraduate program. That might be all taken care of, and there are no problems. And again, we probably take no further action on that. We could ask people to enter into a voluntary agreement. As the term suggests, this is voluntarily, and it depends on the person accepting the agreement. So a voluntary agreement might be that the board receive reports from their general practitioner or specialist that they may be seeing. That's just to help us to keep a check that things are okay and the person's health is being monitored, and that's not affecting their practice. We can place conditions on the scope of practice of a practitioner. So we might require them to have supervision. We might require them to tell their prospective employer or employer that they have a health condition. So the conditions we put on there would be proposed first to the practitioner, and they would accept those conditions or present information as to why those conditions should not be placed on their practice. We can refer for a medical assessment, and this is at the board's expense. So this is where we would ask a medical practitioner, psychologist, psychiatrist, occupational health physician to provide a report to the board. The report comes to the board, but before it goes to the board, it actually goes back to the practitioner, who is able to make comments on what the report is saying about their health condition. And then it goes to the board, and the board then might say, we're entering into a voluntary agreement, or we can place conditions on that person's scope of practice. We can also, in serious cases where people have got a health condition which is affecting their practice, and this is usually around a mental health condition that they've probably got no insight into, we can actually stop them from practicing. But we have to go through a clear process before we do that and stop people from practicing. So the person has an opportunity to be heard on the matter of why the board should stop them practicing at this time. Fitness is usually at registration under Part 2 of the Act. And this is somebody who is new to register, such as a new graduate, somebody from overseas, somebody returning to practice who's had their registration lapse, or somebody who's been removed and wants to be restored back to the register. So the requirements under the Act is that they can communicate effectively, they can communicate and comprehend in English, there are no convictions that would preclude them from practicing, there's no mental or physical condition, and there's no professional disciplinary proceedings or investigations that have taken place in New Zealand or another country. So that fitness to practice covers both mental and physical health, as well as fitness around the conditions such as communicating in English and not having any proceedings against you. Competence. Notifications that practice is below the required standard of competence. So who can notify in this particular instance? a practitioner A can complain about the competence of practitioner B, and the Act says that they may notify us if this is the case. Practitioner A thinks that practitioner B is practicing below the required standard of competence. They may, if they want to, let us know. The Health and Disability Commissioner must tell us that there is an issue of competence with a practitioner. Employer, if a practitioner is dismissed for competence reasons, they must notify us, and of course a member of the public can let us know that there is a competency issue with a practitioner. You have to hold a practicing certificate for a review of your competence. So you might be on the register but not currently hold a practicing certificate. If that's the case, we cannot assess your competence because you aren't practicing, so there's no way of testing competence in that situation. And the board can review competence at any time, and our process is that if we've got concerns about a practitioner, we would let that practitioner know that we are going to review their competence and signal why we think we need to do that, and there's an opportunity for that practitioner to respond to that. And remember also that your e-portfolio demonstrates ongoing competence. So we do look at the e-portfolio, your e-portfolios, when we get notifications coming in, and we obviously also audit e-portfolios annually, although COVID-19 has put a bit of a hiatus on that at the moment, but we're planning to start or re-auditing soon. So in relation to competence, what action can the board take? Well, again, following assessment, the board may take no further action, and it has to explain why it would do that. Again, voluntary agreement can be used around competence, so we might ask somebody to demonstrate some activity within their e-portfolio. We might ask them to engage with a particular type of supervision, which looks at an area of practice that has been identified as an area where competence is an issue. We can undertake a competence program. We can ask the practitioner to undertake a competence program, and that usually is in the form of a study. It might be around a paper that has to be completed. The person can sit an examination, and this very rarely happens, but it happens where people have maybe been registered, had a practicing certificate, and then there has been real issues around their competence and their continuing competence to practice. We might ask them to sit an examination. They may be counselled or assisted by one or more nominated people. We can place conditions on their scope of practice, and we can undertake a competence review of the practitioner. So that review is usually undertaken by two people. One is a layperson and the other is an occupational therapist who can actually go to the person's practice and actually watch them in practice to see what they're doing. The other option that we sometimes do is a paper-based competence review, where the person may be given a number of scenarios and asked to respond to that, and then the competence reviewers would look at that information and provide a report back to the board. We can also use facilitated resolution. This is a policy and a process that the board has in place. It's been there for a number of years now. And as the name suggests, it is about facilitated resolution through arbitration, mediation process, where we would get an independent mediator to meet with the practitioner and the complainant or the employer to look at how they can resolve the issue through mediation and agreement. This has been useful sometimes for people who have complaints from the driving assessors, where they've made a decision about a client who they say can no longer drive, and there may be issues around the competence of, or the client raises issue around the competence of the assessment. So that can sometimes be used there to resolve issues. So in relation to competence, what action can the board take? If there's serious risk of harm, and there's There's two stages to this. There can be risk of harm, and then there can be serious risk of harm. The practicing certificate of the practitioner can be suspended. The scope of the practitioner can be altered, and ultimately the practitioner can be stopped from practicing. Of course, with these, there are certain steps we would go through to notify the practitioner that we're taking this approach, and there's opportunity for that person to come back and make representation or be heard as to why the action the board is proposing to take should not be taken. The complaints, notifications of practitioners or conduct has affected a health consumer. So who can notify? Well, obviously a health consumer, and if a health consumer does notify us that there's a concern or makes a complaint about a practitioner, then it has to go to the Health and Disability Commissioner. So no action by the board is taken while that notification or complaint is with the Health and Disability Commissioner. That sometimes takes time for the Health and Disability Commissioner to consider the assessment, make an assessment, and then take action under their legislation. I think it's important to point out here that the assessment or the lens that the HDC use is different to the lens that the board would apply to a complaint. So the lens that the HDC uses is the Code of Patient Rights. So looking at the complaint, has the Code of Patient Rights been affected in any way with this complaint? And that's the action and the way that they look at it. Whereas we look at it in relation to the competencies and code of ethics and any guidelines that we've produced that would suggest that there is a cause or a consequence of the complaint that's been put forward. It's interesting also that when we get a complaint, we tell the practitioner we've received a complaint, we tell the complainant that we've received that complaint, acknowledging that, and we tell them that it's been sent on to the Health and Disability Commissioner. Then it might come back to us from the Health and Disability Commissioner if they think that the board, in the lens that it applies, would best suit addressing the complaint. So for a practitioner, and to some extent for the complainant, it may feel like there's double activity or a doubling of activity going on here. You know, practitioners can be forgiven for thinking that if it's been to the HDC and the HDC has decided to take no further action, that's the end of the matter. But it actually comes back to the board, and the board then look at it through the lens of the areas that I've mentioned around the competencies for registration and continuing practice, code of ethics and guidelines, etc. Employers can send in complaints, and the registrar of the court can send in complaints or notifications of convictions. Interesting, in all my years here, we've never had a notice of conviction coming from a registrar of the court. Of course, that all depends on the court realizing that the person who's facing charges or allegations is in fact an occupational therapist, and they're meant, according to our legislation, to report any convictions which carry 3 months prison sentence or more, or a fine of $10,000 or more. They should report that to us as the regulator. And that's just a note at the bottom there to say that the HDC has separate processes to the board. So it may feel like the practitioner is going through two processes. So when we get a complaint, what action can the board take? Well, we can refer it to a professional conduct committee for investigation. It's important to note that the operational staff, myself, and the board for that matter, cannot investigate complaints. We can make further inquiries, but if we want the complaint to be really investigated properly, then we have to appoint a professional conduct committee to undertake that investigation. And that is usually a 3-person committee a layperson and 2 occupational therapists. Look at the complaint, meet with the complainant, meet with the practitioner, look at all sorts of information. They can gather information and investigate what the complaint in its totality. We can ask the person to undergo a medical examination if we feel that the complaint relates to some health condition the person might have. They can undergo specified psychological or psychiatric examination, counseling, or therapy. Again, that might be suggestive that the complaint has its origins within a health condition. And attend therapy for alcohol and drug abuse, place conditions on the scope of practice again, and we can put an interim suspension on the practicing certificate. And again, we can move to facilitated resolution if it's appropriate to do so with the type of complaint that we're dealing with. So having said all that around the notifications we receive, in a typical year, the board would receive the following. So around competence, 4, these are average. Conduct, sometimes get none. Some years we'll get 9. Convictions, probably 1 to 5. And complaints to the HDC, 6 or 9. And health conditions, maybe 5 to 13. And those that go to a professional conduct committee in any year might be around 1 to 2 each year. So what are the sort of health, competence and conduct issues that come to the board? Well, normal everyday health issues, the occupational therapists are not immune to developing normal everyday health conditions such as depression and serious health conditions, mental health conditions like psychotic episodes and addictions. Inappropriate postings on social media, that sometimes comes up, and we produce guidance around electronic communication and the use of social media. Inappropriate relationship with clients, poor communication between the practitioner and client, poor attitude of the practitioner, poor record keeping and altering records, poor performance, practitioner on a performance improvement plan. So that often happens, and what we usually do if the employer is taking the practitioner through a performance improvement plan, then we leave well alone and allow the employer to work with the practitioner, and the employer just lets us know if there is an issue that it's not being managed within the performance improvement plan. And criminal convictions, so drunk in charge, assault or careless driving causing death or injury, inappropriate use of position to obtain equipment, and driving assessments is something that we're getting quite a few of nowadays with an aging population. So hopefully that's the end of my presentation. Happy to receive any questions from anybody, if you have. Happy to take those. You want to just take those into the Q&A box. Okay, looks like nobody's got any questions. Oh, here we go. Yes, there are 2. Thank you for that. So nothing to ask, just thank you, Andrew, for your time. That's good. Thank you, Jill. And Gail, can you explain the last point about driving assessments? Yeah, can do that. We have obviously a number of occupational therapists who assess clients, usually the elderly, for driving. Assessment about them, repeating having their license. It's usually a referral from a general practitioner that goes to the occupational therapists to then assess the person for ability to continue to drive. There's different platforms that online platforms that the therapist will use to do that assessment. It's usually an off-road and an on-road assessment. And what happens, it's obviously a very emotive thing to be faced with, for the client, faced with the fact that their license may be withdrawn. And that might be the ultimate decision that the practitioner makes to the general practitioner. And so there's heightened awareness from the client around how the practitioner is making that decision and how they've made that assessment, whether they feel it's fair or not. So it is quite a process and a quite sort of emotive issue to be faced with. And because we have an aging population now, occupational therapists are having to do more and more driving assessments, and people are finding that they're having their license either adapted in some way that allows them just to drive within a 20-kilometer radius, or more seriously having their license removed, so stopping them from driving. Yeah, so that's what's happening there. Hope that explains that point. We are producing in the process of producing guidance for those practitioners who do driving assessments, and vehicle modifications as well is another part of that, but doesn't tend to get reported as much as the concerns following a driving assessment. Okay, well, if there are no further questions, thank you for that. Thank you for joining us, and hopefully you find the webinars of interest. And we try to present on a range of things around our functions, trying to break down that barrier between the practitioners seeing the board as this sort of unapproachable organization to an organization that you feel you can have a conversation with when you're facing difficulties. And we won't sort of come down heavy and hard just because you're talking through a particular problem. So hopefully you find that you can do that and approach, find the board approachable. Okay, thank you everybody, and see you next time. Thank you.